What's up, everyone? It's Captain Kyle Smith, and this week I sat down for a morning meeting with estate planning attorney Lori Bolander. Listen in as Lori outlines everything you need to know about how to create an estate plan and why it's so important for first responders to have something in place. Hope you guys enjoy it. All right, hey Lori, welcome to the bullpen. Thanks for meeting me.
Thank you. Thank you for having me.
Yeah, I'm excited to have you on here. We're going to dive into your first alarm here in a minute, that'll give you an opportunity to just tell us who you are and your story and everything. I actually found you through our Relief Association. I came across an advertisement in one of our flyers for your firm there, and I reached out to you just out of the blue, and you were more than accommodating for us, and I'm just really excited to have you here. How has this pandemic affected things in your line of work?
Well, we've been very busy. I think it's a combination of people realizing there's a pandemic, a major health crisis out there, and maybe feeling a little more vulnerable to getting ill or dying, for that matter. And also, some of them have had a lot more time at home to do things that maybe are kind of been on their to-do list. I know people have been cleaning closets and things like that, and they've kind of been, cleaning out their financial closet and their to-do list as well. And estate planning always seems to be kind of far down on people's lists. And so I think it's kind of risen up a little bit as they've had a little bit more time during the pandemic.
Wow, that makes perfect sense when you put it in those terms, cleaning out your financial closet. I just love that. That's just a perfect way of putting things. And estate planning, which we'll talk about more here in a minute, is a crucial piece of financial well-being. But it is something that tends to sort of slide down the priority list. And for people in our line of work, that really can't happen. So I'm anxious to get into your first alarm and find out more about what you do and what estate planning actually is. So if you're ready to get going, let's do this.
All right.
All right. So Lori, first alarm assignment on the San Diego Fire Department consists of 4 engines and a truck, but here at the FIREhouse, I'll ask you 4 questions. You give us 1 piece of advice. That sound good?
All right.
All right. So when you're first in on your first alarm, you have to give a size up, and a size up is who you are, where you work, and how long you've been doing it.
Okay. I am Lori Bolander. I am an attorney, trust and estates attorney. I do estate planning, trust administrations, probates. I used to do a lot of litigation in all of those areas, but I've been doing a little bit less of that. I work at Gallagher Bolander Smedley here in Ocean Beach, and I've been doing it for about 15 or 16 years as an attorney, but I actually worked for an attorney that did trust and estates while I was in my senior year of college and all 4 years of law school, all 3 years of law school.
Oh, wow. That's a lot of experience. Sounds like you're a glutton for punishment. But for those folks that are listening that aren't from the area, Ocean Beach is a part of San Diego here, right? Obviously right on the beach. It's a really cool part of town. So just to help folks that aren't from this area. Now, talking about estate planning, why, Lori, is it important for first responders, firefighters in general, or in particular, to have that estate plan in place? Is it for everyone, or is there sort of a trigger point where it makes more sense for us?
Yeah, I mean, I think it's important that anybody have an estate plan in some way, shape, or form, but especially first responders, just because they're, in the line of fire a little bit more and a little higher risk of having something happen to them. So it's important for their families as well as themselves. And what that really basically consists of, and there's different trigger points for this, but a trust if it's appropriate, a pour over will if you do have a trust, and healthcare directive and power of attorney. Those are kind of like the basic documents. And the trigger between whether you have a trust and whether you have a will is generally a probate consideration. And our probate limits in California are $166,250. So if you have assets outside of your trust or not in a trust at all, that total that, then everything is supposed to be probated. Now, for real estate in California, the trigger is $55,000, and that's your gross value, not your net value. So basically, any real estate in California would trigger a probate. And so those are the documents that generally we're setting up for people, and they're important for your personal well-being, that your health medical decisions can be made if you can't make them, and also for your finances, so that somebody can continue paying your bills if you're incapacitated. And then obviously if you die, then somebody can take over and distribute things to your beneficiaries.
Okay, that makes sense. For our folks, they're going to be really familiar with sort of end of life directives, like advanced directives for healthcare. Those are documents that we come across all the time for people that are at their, sort of the end of the road there. But you mentioned two things, or a few things there that I want to just dig into a little bit more for people that maybe aren't as familiar. You mentioned a will, a pour over will, a trust, and then also probate. Can you just go through those for us just briefly? Just so we kind of understand the difference. Those are terms that we probably all heard, but might not be that familiar with.
Yeah, absolutely. I know. I always say that about probate is like everybody knows that they don't want to go to probate, but very few people actually really know what it is. And essentially what it is the court procedure of taking assets out of your name when you die. The state wants to ensure that whoever's taking your assets is the proper person to be doing that. And we've got, if you don't have a will, we have intestate succession. And so if you do have a will, it doesn't necessarily avoid probate. Your assets are still in your name when you have a will, and therefore, if you hit those triggers of the probate amounts, what happens is the will just gets submitted to court and is probated, and the judge follows, who you want your executor to be and where you want things distributed, but it doesn't actually avoid that process itself. And probate's obviously very expensive, especially in California. There are some states where probate is quick and it is cheap. It is not that whatsoever in California. It is expensive and it is a very long process. The pandemic has backed that up even a little bit more because the courts actually shut down for a while. They were running on lower staff, and so everything's just pushed back. So it's gotten to be an even longer process. And so a will, is a document that you set up and you can name your executor and you can name where you want things to go. But it won't avoid that probate. And the reason a trust avoids that probate is because when you execute your trust, you actually retitle your assets, including your real estate and your bigger accounts. So some of the smaller ones, as long as we don't hit the $166,250, can stay outside of the trust. But we get all of the main assets into the trust. And then when you die, or if you become incapacitated, then whoever you've appointed as your successor trustee just steps in to those shoes, takes over the assets, and does what your trust says to do with them.
That makes sense. And so is that technically like the ownership changes itself? Like is the deed?
Yeah. Yep. Exactly. We actually prepare deeds and record them with the recorder. And so your property is actually owned by you as trustee. And then the trust says, when I'm not the trustee anymore, then, my son John is, or whatever the case may be. Okay. And then the other piece that kind of plays in with the trust is the power of attorney. And that is a document that allows somebody during your lifetime to handle financial affairs. When you have a trust, that's only for things outside of the trust. And one of a good example of one of the types of assets that would not be in your trust is your retirement account. Your retirement account can't be titled into the trust, but you can name beneficiaries. And there's sometimes, especially with like a husband and wife, or let's say husband died and, mom's now 90, husband's been gone for quite a while. Son realizes dad's the beneficiary of mom's retirement account. What are we going to do? Well, if you have a power of attorney, you can go in and change that.
Okay, that's gonna make a lot of sense to a lot of our folks, because we can go in ourselves in our retirement accounts and assign beneficiaries. That power of attorney thing is a key component to that. Now, just circling back a little bit, Lori, any idea how long probate is taking today in a pandemic?
Yeah, I used to say a minimum of a year. It's probably more a year and a half to 2 years at this point. And part of that is because there's a minimum of 2 hearings that you have to have in a probate. One is to get you appointed. And so you have to get all your paperwork together, get the petition together, get it filed, and then the court sets you a date. That's usually a couple months out at this point. Once you get that, and the court approves your appointment, then you have to get the documents from the court showing you've been appointed. And that usually takes a few more weeks. And then the day you're appointed, a clock starts ticking for a creditor's claim period, and that's a 120-day period, so that's 4 months. So your probate has to be open for a minimum of 4 months. In very simple estates, like I've got one right now where we just have a house, right at the end of that 120 days, we can start kind of bringing the petition together to close the estate. But those are set out even farther because those are accountings usually, where the court reviews what what happened within the estate. And so that calendar takes a lot longer. So those are being set out like 3 or 4 months at this point. And usually after the 120 days, we're not quite there anyway, because we have to give, notice to the franchise tax board and the IRS, and we have to make sure all the taxes are paid. And sometimes that just doesn't happen as quickly as we want to. I've got one estate that we can't close because we've got so many unresolved tax issues. And it's just lingering and taking so long. And that's partially because the IRS has been understaffed and overwhelmed, and especially during COVID.
Yeah, no, that makes sense. And I just want people to be clear on this. If one of us passes away without anything in place, I think you said it's called intestate, Lori. That means that whatever assets that you have that you would want to pass down to your beneficiaries, that you'd want to pass down to your heirs, gets tied up for months and months and months. It not only is it just a nightmare, but you're not going to be able to pass anything along to the people that are suffering. And that's it.
Right.
Now, what about for the person that says, you know what, my family's in a great place. If I pass away, we're not going to be worried about the timing of it. So what? It's a couple of months. You mentioned the cost is really high. Is it a percentage of the estate, or how is it? How are those fees factored in? Like, why not just go through probate if you're not worried about the time, instead of paying all this money for a will and a trust? Why not just go through probate?
Yeah, the fees are statutory, which means they're set by law. So it's not like most attorneys aren't going to negotiate with you on that. It's like, well, if I take a probate, I get a statutory fee. That's how it works. And they are a percentage, and it's based on the gross value of the estate. So again, it's not your net value, it's your gross value. So if you have a house that's worth $1 million, but you owe $900,000 on it, you're still paying fees of $1 million, even though the estate's going to let net less than $100,000. So that's one of the problems. And then the percentages, and by the way, the executor of the estate and the attorney are entitled to the same exact fee. So you take this number and you double it, presuming that your executor would take that fee. They don't all take that fee, but often they do, because it's a lot of work. I always encourage my clients to take their fees, because it's a lot of work, and it's also liability. You've got liability associated with it. But it's 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and then 1% of the next 2.5 million. And then after that, it's in the judge's discretion. So most probates I'm seeing, by the time we get down to the 2%, that's the majority of the estate.
Sure. But that is a significant amount of money.
It's a significant amount of money. I think the lowest probate fee I've ever had is like $9,000. And, that's like when it was like one bank account or something like that.
Right. And so not only is it extremely expensive, like you said, it is also very time consuming.
Yes.
And that's why it's so expensive. For us, is there a better option? Is it get a will is better than a trust? Is there one that's better than the next, or is there a combination of maybe a couple?
Yeah, so it's going to depend on the asset level, and also whether or not you have minor children, because minors can't inherit under the law. And so if they get anything over $5,000, then a guardianship procedure has to be instituted in the probate court. That is also an expensive and time-consuming procedure. So if you leave things in a will to minor children, then somebody will have to go in after you die and get a guardianship. And so those are the two triggers. You've got assets that qualify for probate, or you've got minor children. And so if you've got those two things, then a trust is going to be your better vehicle. And, for a full estate plan for trust and a pour-over will, which is a will you have with a trust, it's a different kind of a will. Your power of attorney and your healthcare directive, the majority of the attorneys I know are charging for a single person maybe somewhere between $1,500 and $2,000 for that. And for married couples, somewhere probably between $2,000 and $3,000. And, a lot of attorneys will let you pay overtime or something like that as well. So it's really a significant cost savings to do that. Now, there's still costs of administering a trust, and those are taken out of your assets after you die, but they're very minimal in comparison to probate.
Yeah, it's, I mean, what I'm hearing is it's a third of a third of the cost and practically none of the time. But the one thing that you can't really put a value on is the peace of mind you're giving the people that are still here after you go. And that for me was
Yeah.
that one for me was the one that just sealed it. Like I have to get this taken care of so that I know that
Yeah.
whenever I'm gone, they're going to be well taken care of. Now, kind of with that in mind, Lori, what's like when it comes to estate planning in general, aside from just not having a plan in place at all, what's sort of some of the biggest mistakes that you see?
One of the biggest mistakes I see is that people don't fund their trust, meaning they don't put the assets into it. And so, or they did, but then they somehow got out because things have changed over time. They put their bank account in the trust, but then they moved banks and then they didn't put the new one in there, or they bought their house and put it in the trust, but then they sold it and bought a new one. And what happens is, if you do that and you die, the trust is unfunded. Technically, under the law, it fails. So then it's like you have no trust at all. Now, there are procedures that we can go through to kind of try to get assets back into the trust. And the key component of that is a schedule that we attach to your trust, your schedule of assets. And just by having things listed on that trust schedule, we can keep them from going through probate by using a different type of petition that's quicker and cheaper, much easier than a probate. But it's kind of we don't want to do that. We want everything to be titled in the trust so it's seamless rather than having to go to court at all. So I always encourage people, the number one thing is title your assets in your trust. Number two is update that trust schedule. So we at least have a backup. And that's what I see a lot of is either there was no trust schedule whatsoever, and then the assets get out of the trust, and then we're stuck with going to court, which is one of the reasons we did the trust was to avoid to do that. So.
Oh gosh, that makes a lot of sense. How often do you recommend somebody updates their trust? Is it every time they switch banks? Is it every time they purchase property? Like how do you quantify that?
Yeah, I mean, with their trust schedule, what I've been doing lately is actually separating it off the trust and emailing the Word version to people and saying, look, I'll update it for you, but if it's easier for you to keep it updated at home, then that's fine. That way they can just go in and update it whenever they want. So the trust schedule itself should be updated every time you change assets. And it's more important to get the new ones on there rather than take the old ones off. Because they would just be moot if they were on there and they didn't exist. But as far as the trust itself, I always tell people, people say, oh, you should look at it every 3 years or every 5 years. And that's a good rule of thumb because what I notice about clients is they don't really remember what's in their trust. So it is a good idea to get it out. And people go, oh my gosh, I didn't realize, my brother Bob was on here. What were we thinking? And so, it's really their decisions in their own life or their circumstances that may have changed that they should look at. And I like to put a lot of contingencies in my document. So if you named, your sister Sue and she passed away, we've got somebody behind her. That's not like going to be an emergency. Yes, we can get it changed when you've got the time, but that's not going to be an emergency because we have a backup. And same with beneficiaries. We've got some alternate distributions there because I've literally seen trusts come in that had one trustee named and one beneficiary and they were both dead. So guess what happens? We go back to court.
Oh man. Well, this is super important, and I'm speaking for myself here. This is really valuable information for me to hear. I think I have to clean out my financial closet and go back and pull that trust out. Now you were sort of mentioning, we can update the trust on our end a little bit. That's going to perk up our ears, I'm sure, because we as a group of people, a population of people are can do attitude, type A personalities. We want to solve the problems, right? That can get us into trouble. So I want to just ask you this, like, why should we shell out all this money to go to an expert, an attorney, to create a trust rather than just, I don't know, scratching it out on the back of a napkin over here and just calling it good? Why do we need to consult with an expert with these?
Well, you want to make sure that what you're doing is legal and going to be enforceable. So I have people say, well, why shouldn't I just spend, $400 to do the one at Office Depot? I said, well, go ahead and do it, but it might be a way to waste $400 because it might not do anything for you. The other thing that a lot of my colleagues and I say about, those types of trusts is, yeah, go ahead and do it. I mean, basically just going to make us money because invariably they land on our desk and we end up fixing it all. And it costs way more than if you would have just done right the first time. I had one client that was like, oh, we just did it on LegalZoom before we left for Europe one year. And I looked and I said, well, they had 2 children. They said, yeah, we just have our siblings in charge of our money for our kids. No, they did not. They had their siblings as beneficiaries. Their kids were not even beneficiaries of the trust.
Oh,
so that could have gone terribly wrong, but thank goodness we redid it and got it all up to speed. But they had that trust in place for probably 10 years. And so thank goodness nothing happened.
Yeah, no kidding. We get ourselves in trouble with these sort of things. So guys, whoever's listening to this, please do consult the experts. Call Lori. She will get you squared away. She would, I'm pretty sure that we would never call you to come put a fire out down the street.
Right.
We should absolutely consult with experts when it comes to planning your estate. So please do that. Now, just kind of fast forwarding, what would be let's imagine somebody winding down their career, getting close to a retirement age. What would be one piece of advice for them in terms of estate planning?
Yeah, I would say that if you have an estate plan, it'd probably be a good idea to look at it, make sure it's up to date. If you don't have one, you get one in place. And one of the reasons I say that is, and kind of everyone considers themselves young as long as they feel young, right? And sometimes that's into their 90s. I've got a guy that plays tennis every day. He's like 93 and he's doing great, But it's good to have it in place because as you age, your motivation and your ability to get things like this accomplished gets harder and harder. And then you could end up in a situation where you don't have capacity to do these things. And then you end up in a conservatorship situation. So, there's so many clients I've seen lately that their husbands have Alzheimer's or dementia, but they've had a plan in place. But, once that happens, then you've crossed the line of being able to do an estate plan. And if you get in that situation, you end up in this conservatorship proceeding, which basically is appointing somebody to be your power of attorney or healthcare agent. And it's very expensive. I always say it's worse than probate because you're alive. You're going through this court proceeding. And they can be very contentious because then you get siblings and children fighting over positions of power.
Yeah, no, that sounds horrible.
And money.
Yeah, sure. Now for you specifically, Lori, you've been vetted by our Relief Association, which is great. Now, do you offer services out of your office for folks that are not in the San Diego area? We have listeners from all over the country. Would that work?
Yeah, as long as they're California residents or have assets in California, I can help them. I've got clients, in the Bay Area, all over California, especially in this day and age when we're doing a lot of Zoom and phone calls. It seems to be working out just fine. I had a lot before all of this came about, but if they've got property in California or are residents of California, I can help assist them with that. And I do have a lot of connections in other states as well. So somebody's just like, I don't have a referral. I am on a listserv with other attorneys that work with attorneys in other states all the time. So some states I've got my own people that I know personally. And if I don't, I've got a colleague that I know personally referring me to somebody. So happy to be a referral source as well.
Perfect. Awesome. Well, gosh, that is a ton of information, Lori, packed into one first alarm. But I think with that, looks like you got knocked down. So if somebody is looking to contact you or get in touch with you or maybe look for a referral for someplace else, how could they find you?
Yeah, we've got a website if you want to go there. It's lawgbs.com. So LAW, G as in George, B as in boy, and S as in Sam.com. And that's got all of our information. And I also have a pretty simple document that kind of summarizes what is probate, what's a will, what's a trust, what's a power of attorney, what's a healthcare directive, why do I need these documents? So if anybody's ever interested in that, I'm happy to email that to you as well. And my email, you can get to us through the website as well.
Oh, that's perfect. I'll link to all that stuff in the show notes so people have access to it. Laura, I just thank you again for your time today. This has been fantastic. Anybody that's listening to this, please do reach out to Lori or at a minimum, find somebody that can help you put together this estate plan before something terrible happens and you can't make the decision on your own. So yeah, with that, Lori, I wanted to say thank you for your time today.
Yeah, absolutely. Thank you.
All right. Hey, thanks again to Lori for meeting me here in the bullpen. Guys, if you're listening to this and you don't have an estate plan in place, do me a favor, just press pause, give her a call, and find out if you've hit those trigger points she was talking about, to where you do need something so that your loved ones aren't left going through the nightmare that is probate. The amount of time it takes to pass down your assets to the people that you want to have, on top of all the money it's going to cost you if you do have to go through probate, is just a nightmare. Trust me when I tell you, you do not want to do that. If you'd like to learn more about Lori, you can find her on their website at lawgbs.com. lawgbs.com. If you'd like to learn more about us, we're on Facebook at The FIREhouse. That's f.i.r.e.house. On Instagram, the _fire_house. On LinkedIn, The FIREhouse Investors, or any place you listen to podcasts. If you learned something today and you'd like to hear more, please like, share, and subscribe. But no matter what you do, take this information, go out there, and get some. Station F.